All right, good morning. I'm Judge Stanley. This is Division 2 of the Coconino County Superior Court. We're back on the record in State of Arizona versus Francis Cruz Mendoza-Keel, CR 2025-00513. And the court will just note the presence of both counsel for the state as well as the state's case agent. The court also notes the presence of Mr. Mendoza-Keel and also defense counsel. At this time, the jury is not present. I think we're about ready for closing arguments, but I understand the state wants to look at page 27 of the instructions. Is that right?
I think I have the correct page numbers from the most updated version, but yes, I believe it's 27. Officer justified in using threatening physical force.
Okay. Tell me where. I understand that you're thinking there's an additional or that should be somewhere, so take me to it.
In the number, paragraph 3, the officer made known to the other person the purpose of the arrest or detention. There's just a comma there. The statute that this is based off has an or between that first clause and the second clause. I do think it's important. I think without that or, it could reasonably be read to read that both clause 1 and 2 of that paragraph need to be met, whereas the statute is clear. It's any one of those 3 clauses.
Give me just 1 second. I want to print out, I meant to print out the entirety of the instruction from the Rajis and bring it out, and I only did the second page and the part that you're talking about on the page before that. I'm going to just grab that and then I can look at it later, I think.
It's based off the Raji. Raji is based off the statute. 4.09, I think.
All right, you're looking at number 3 there. Let me just compare. And where are you suggesting the additional or, Mr. Kent, now that I'm looking at it?
So there's basically 3 or 4 clauses, but between the first clause and the second clause, so where there's a comma after detention.
Okay. All right, does this defense agree?
Yes, Your Honor.
I think that's appropriate, and I deliberately left all the possibilities in it when editing it to for use. So I agree. I'll bring that to the jury's attention and have them make that change in their copy. And I've made that copy or that change in the copy that's serving as the original, which I'll turn over to the clerk after closings. Anything else before we bring the jury?
Nothing from the state.
All right, in that case, Mary, if you'll go ahead and let Daniel know. You didn't either, Mr. Hartman.
Sure. Could I just have a 30-second bathroom break?
Sure.
Thank you so much.
30 seconds to count. you look at the statute, it's button up there, there's just an or between each other.
All right, I think we're all set, Mary. You can let Ernie know that we are ready for the jury. Is the state ready to have the projector turned over?
Yes,
You?
we're ready.
Okay.
And Your Honor, we're going to be using two exhibits during our closing, but I think we can just leave the lights on because it just has text. I think it'll be visible.
Okay. If anybody wants the lights up, down, or anything, just ask Ernie to do it. He'll be sitting right by the light switch and can do it for you if you change your mind.
Perfect. Thank you, Your Honor.
Yep. All right, looks like they're probably coming here. The jury. Thank you. Please be seated. All right, welcome back to our jury. The record will reflect that the jury is present at this time. This morning, before we proceed with the closing arguments, there was one small additional correction I want to have everybody make in your instructions this morning. If I could get each of you to turn to page 27. On page 27, if you go down to the paragraph that's numbered 3, we're going to place the word or in there. I'll show you exactly where if you just read along with me. It should state the officer made known to the other person the purposes of the arrest or detention, and then comma, and there should be an or right there, or the officer believed that the other person knew the purpose of the arrest or detention, comma, and then as the next part of the sentence indicates, or the officer could not have reasonably made known to the person to be arrested or detained the purpose of the arrest or detention, then and. So did everybody follow where we added that or in? All right, everybody's shaking their head yes. All right, we just had that small but important correction to make. And at this time, I will turn it over to the state for its closing argument.
Thank you, Your Honor. This is a simple case. The defendant's on video committing the aggravated assault he's charged with in counts 1 and 2. He admitted he did so on the stand. There's no dispute about the actions that happened between him and the officers, the physical actions. Counts 3 and 4 aren't on the video, but you heard convincing testimony as to what happened, how Howard Leventhal was threatened, his car was shook, and he was smacked in the head, his glasses flew off. This is the easy part. We know the defendant committed these crimes. He knowingly touched each defendant with intent, each victim with intent to harm them. So the only other possible question for your consideration in this case is, was he justified in doing so? Does the defendant have a legal justification of self-defense in committing these crimes he committed? The answer to that is easy also. It's no. It's a straightforward reason, no. Was the defendant acting in reasonable self-defense? Was he justified in throwing punches and headlocking these officers who did nothing more than tell the defendant he was under arrest and try to place him under arrest? Given these 2 points, the only thing left to do in this case is to follow your oath, follow the law, and find the defendant guilty on all counts. One of the themes of this case and of your instructions is common sense. One of the most important moments in this trial is the reading of the instructions. It's long, it was at the end of a long day, but it's important because there's a theme in those instructions, and you might not realize it at first, but the theme is reason, common sense, and experience from everyday life. That's an instruction in the instructions that were read to you and given to you that you must follow. You have to use your reason, common sense, and experience from everyday life in deciding the facts of this case and how the facts of this case are applied to the law. That's going to be easy. When you see this image and the videos associated with it, use your common sense. What is happening here? Is a running jump to jumping punch at an officer's head reasonable considering what had happened in the moments leading up to that moment? So this is from the instructions. It is your duty to determine what the facts are in this case by determining what actually happened. You determine what happened. This seems obvious, but court might seem like a strange place, but it might seem theoretical, but it's not. The judge told you that you determine what actually happened. You bring the real world here. You decide a real thing, something that actually happened. Your job here is not philosophical. Your job is to determine what the facts are of this case. If both parties happen to agree to a fact, such as the defendant agreeing that he hit these officers, that makes a fact likely it probably happened. But at the end of the day, it's your decision to accept what facts happened or not. So again, the theme of reason, common sense, and experience from everyday life permeates this. It's a very important instruction, and it also tells you how much weight to give to any testimony. This is from your instructions. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life. You evaluate the testimony you heard, and you determine what truthfulness or credibility, what weight to give the evidence you heard from the witness stand. Again, court's not some weird, abstract, theoretical place. You don't come in here and believe things you wouldn't believe in real life. You use the same tests you would in real life to determine if something is true or not in determining what happened in this case. So some of those things that you can consider are manner, how someone testified. What was their manner in testifying? Was it organized? Was it clear? Did it make sense? What motive did they have? Did someone testifying have a motive to spin the facts one way or the other? Or another thing you can consider in assessing the credibility of testimony you heard is felony criminal history. If you heard that a witness had felony criminal history, you can use that to determine whether their testimony was credible to you or not. Another instruction you have, the reasonableness of the witness's testimony when considered in light of the other evidence. So it's in your instructions. You have to consider the evidence in light of all the other evidence. Why is this important? Think about the trial process. It's very technical. We go one witness at a time. It might be an unusual way to learn a story or learn the facts that happened one witness at a time. And you might have a temptation to look at one witness and think something they said was strange or wrong and throw out everything else they said. But that's not what the instruction says. The judge instructed you to do the opposite. You need to consider all of the evidence in light of all the other evidence. So again, and this goes to considering the evidence, considering the credibility of how you heard that evidence. Was it on video? Was it testified to? And how credibly was it testified to? Again, in your instructions, consider all of the evidence in the light of reason, common sense, and experience. You were instructed on the law in Arizona that's applicable to this case, and you swore an oath to follow it as it requires. Those things are why you're here. So bring those things with you to the jury room, and that's how you decide what actually happened. I want to move on to an overview again of the law, applicable law as to the charges in this case. So first we have assault. The elements of assault are knowingly, so you know you're doing it, touching another person with intent to injure, insult, or provoke. As to the aggravated assault charges on the officer, there's undisputed testimony, video, everyone's in agreement that the defendant touched these officers. And it's easy to infer, which you get to do, what his intent was. His intent was to injure these officers or to insult them, provoke them to get away. That's easy to infer what his intent was. Moving on, aggravated assault is the same. It has an assault plus a law enforcement officer, a peace officer. You heard from both officers that they're peace officers. Oh, and I want to go back to assault for a second. one thing that's missing here that you don't see on the screen that you don't have to find is injury. There doesn't have to be physical injury for any of these charges for you to find the defendant guilty. If there is, that you can find that, but you do not have to find that to find the defendant guilty of assault or aggravated assault. The state does not have a burden to prove injury to anyone in this case. The last charge, disorderly conduct. A person commits disorderly conduct if intentionally or knowingly disturbing the peace or quiet of a neighborhood, family, or person by engaging in fighting, violent, or seriously disruptive behavior. Here, the state's theory is that Howard Leventhal was the person whose peace was disturbed as the defendant grabbed his car, shook it, reached in, and hit him in the head. So again, at this point, it should be very clear to you, if it wasn't already abundantly clear, the elements of these crimes have been met in this case. A lot of them were admitted to by the defendant. There's just no question that there were assaults on the 3 victims in this case. So again, the only other question you have to decide is, was the defendant justified in the actions he took? The answer to that is no. This is from your instructions. As you know, there's a lot of instructions and they're dense, especially on the justification. This is from the justification instruction. A defendant is not justified in using physical force against another to resist an arrest that the defendant knew or should have known was being made by a peace officer, whether the arrest is lawful or unlawful. I'm going to repeat that. A defendant is not justified in using physical force to resist an arrest, whether that arrest is lawful or unlawful. You do not, to return a verdict of guilty, the aggravated assault charges, you do not need to determine whether the arrest was lawful or unlawful. The state's position is obviously it was lawful, and I think the evidence clearly bears that out. But even if you disagree on that, if you think this was an unlawful arrest, that is not sufficient justification alone to find the defendant not guilty. So the last part, not justified, and then there's an unless. So even if there's an unlawful arrest, the physical force by a defendant is not justified unless the physical force used by the peace officer exceeded that allowed by law. So what is this talking about? Exceeded. We're talking about excessive force. Was there excessive force by the law enforcement officers in this case before the defendant attacked them? No, there was not. What happened in this case? The officers arrived, they interviewed the victim, they got his side of the story. They drove through the neighborhood to the defendant's house. They got outside of their car and they talked to the defendant in the yard for several minutes. They questioned him, gave him the opportunity to give his side of the story. At that point, you heard on the video, you saw it several times, Deputy Willis says, at this point, you're going to be placed under arrest, and moves to detain the defendant. At that point, the fight starts. The defendant starts a fight when that happens. Where was the physical force from the officers at that point? Was there any physical force? The state's position is no. Telling a defendant, at this point, you're going to be placed under arrest, that's not physical force. At the very most, touching someone to place them under arrest, one could think maybe that that's physical force. Is that excessive physical force? Because that's what you would need to find a justification defense valid here. How would it, in any universe, be excessive force by law enforcement to have a conversation with a suspect, at this time you're going to be placed under arrest, and move to detain them? In what world is that excessive force? Another part of the justification instruction that's important is this. The force used may not be greater than reasonably necessary to defend against the apparent danger. So I think at this point, we're deep in the rabbit hole, because the only reason you're getting to thinking about this part of the justification defense, if you found somehow that the officers did use excessive force, that does not mean just that alone that the defendant is not guilty based on a justification defense. If and only if you get to the point where you think, I think the officers used excessive force before the defendant attacked them, then you must also look at this part of the justification instruction. Did the force used by the defendant at that point, was it greater than that was reasonably necessary to defend against the apparent danger? I don't understand how this could be the case. What would the apparent danger be of an officer saying, at this time you're going to be placed under arrest? How, even if somehow that's excessive force, is the defendant grabbing an officer, putting him in a headlock, throwing several punches, a running, jumping punch at an officer's head? Is that a proportional and reasonable amount of force to resist or to fight back against this excessive force of, at this time you're going to be placed under arrest? The answer is no. So again, this part of the justification instruction, you're only getting to if somehow you've already found that there's excessive force by law enforcement. So let's talk about what happened just one more time. The officer did announce the arrest. He said, at this time, you're going to be placed under arrest. The defendant, what did he do when that happened? He said, no, I'm not going to be placed under arrest. And he starts backing up. At that point, a physical altercation is clearly brewing, and we know that because that's exactly what happened. There's no more time at this point for the officers to say, sir, we'd like to just discuss this a little more. We can talk about this a little more. No, at this point, it's clear. We heard testimony that the defendant was already in a belligerent state, and the officers knew an altercation, such as exactly what happened, could happen. So at that point, there's no time to say, okay, let's talk about this one more time. You're under arrest for this. At that point, the officers need to act. You're under arrest, and he starts backing away. What is a reasonable officer to do in that situation? Let him run into his car or his house where he might retrieve a weapon, might get in his car to flee? No, at that point, when someone is being told they're placed under arrest and starts backing away, letting you know that, no, I don't agree. I'm gonna fight this arrest. It's reasonable to grab them, to put them under arrest. And again, I'm refreshing you on what happened. I think we saw it several times, but you're going to have these videos in your deliberation room. You can watch them as many times as you need to watch this sequence of events. But when you do, I think it will be clear that there's just no excessive force here. So in a case like this, that's clear, where the defendant is on video committing these assaults, and the justification defense, for the reasons I've just explained, doesn't apply. The other thing the defense does is muddy the waters, put the officers on trial. Let's see if this investigation was perfect, and if it's not, we'll argue that the defendant gets a mulligan. And they did that in a lot of ways. The first one you heard was about this rental contract. What was the terms? When did it change? How much was the rent? Did it go down? Did it go up? Labor, how many hours of labor? None of that is relevant to deciding whether the defendant hit the victim, Howard Leventhal, on the head and attacked these two officers. Whether there was a justified or unjustified rental dispute, not relevant in this case. Obviously, we know there was some sort of dispute about the rent. You don't need to decide who was in the right or who was in the wrong about the terms of the rental agreement, leases, things like that, to decide this case. Another thing that was brought up was the defendant had lost his job. It's on the first page of the instructions that you're not to consider sympathy in deciding the facts of this case. Another thing that the defendant brought out was the audio from the body cameras. As you heard, Deputy Willis had his body camera on, paused it when he drove to the defendant's house, tried to unpause it when he got out of his car, thought it wasn't. Because of that, we missed audio from their conversation, but we sure have video of an audio of the end of their conversation and of the attack. There's no rule of law, and there's certainly nothing in your instructions that say the officer's body camera wasn't on at the start of the conversation. That means the defendant's not guilty. That is not in your instructions. Beyond a reasonable doubt is the standard in this case. It's the state's burden to prove to you these charges beyond a reasonable doubt. And what does that mean? Beyond a reasonable doubt means that you're firmly convinced in the defendant's guilt. That's it. There was a lot of talk from the defense about, could they have issued a summons or a citation rather than a custodial arrest? Again, that's not relevant. The officers testified correctly that they have full discretion to make an arrest. Nothing in the instructions suggests a custodial arrest was somehow illegal in this case. And again, even if there was an illegal arrest, that is not a justification defense in this case in and of itself. So I think the defense is likely to get up here and argue a very incredible argument about excessive force. As I suspect their argument is going to be something along the lines of the officers placing the defendant under arrest was excessive force. Therefore, and it was so excessive that the defendant was justified in attacking these officers. And that's just not the case. Again, common sense says no. The rules say no. So in your instructions, there's a nice one. Let me move back over here. And I might be repeating myself at this point, but the force used may not be greater than reasonably necessary to defend against the danger. So again, that's in your instructions. It's in there twice, actually. It's on page 22 and page 27. That's how important it is that the force used must not be greater, by the defendant, must not be greater than reasonably necessary to defend against the danger he was in. Again, what danger? Therefore, what force is reasonable by him? None. There was no danger here to the defendant. You heard, there was, however, danger here to the officers. You heard testimony about all the ways this can go wrong. When someone grapples you and they can reach for your gun, reach for your taser, it's a volatile situation that it can explode. So did the officers bring the danger to the situation? No. The officers were in the yard talking to him. Their guns weren't out. Deputy Willis's hand wasn't on his gun ready to draw it. They were just sitting about as close as I am to you, having a conversation. There's no excessive force in that conversation. The defendant admitted this. I asked him, was that excessive force when you're in the yard talking? And he said, yes, it was. And I said, explain to me, where's the excessive force there? And he changed his story. Oh, actually, no, that's not excessive force. Yeah, talking in the yard, that wasn't excessive force. He admitted that. So their argument is, the only possible argument that they can make is that somehow placing this person under arrest is excessive force. And that's just not the case. Again, reason, common sense, experience from the real world. That is not excessive force. We aren't in the ballpark here of excessive force. It's not close. So please, follow the law, reach the only logical conclusion, and find the defendant guilty on all counts. Thank you.
All right, thank you. And at this time, Mr. Hartman-Strawn, would you like the overhead?
Yes, Your Honor. Thank you.
And And the defense may proceed when you're ready.
Sorry, Your Honor, I'm going to impede your view a little bit. Morning, everyone. Can everyone see the projector okay? Wonderful. You know, often a defense attorney would get before you and tell you something is flawed about the evidence here, or tell you that it says something other than what the state is saying it tells you. I'm not going to do any of that today. Instead, I'm asking you to find that the state did not prove beyond a reasonable doubt that Francis was not justified in using self-defense against what he believed to be unlawful physical force that was being used against him. First, remember that a person is justified in using physical force against another in self-defense when and to the extent a reasonable person would believe that physical force is immediately necessary to protect himself against the other's use or attempted use of unlawful physical force. You cannot use force in self-defense against law enforcement regardless of whether or not the arrest itself is lawful or unlawful. We're not arguing whether or not what the law enforcement officers on the scene that day had sufficient probable cause to make an arrest, whether or not it was a lawful arrest. We are asserting that, as I said in my opening, that law enforcement officers were not allowed to employ physical force during the arrest at all due to their violation of the law that governs when law enforcement can use physical force. That's a lot of words I just threw at you. But basically the law is stating that someone can employ physical force in their self-defense if someone uses unlawful physical force against them. And again, I'm going to be saying here that the force here was unlawful, not because the arrest was unlawful, but because the law enforcement officers did not meet the requirements to use force during an arrest. Now, law enforcement in Arizona are all instructed on the same aspects of the law when they go through the standardized law enforcement training that we heard both officers went through. Part of this instruction is whether or not they can use force lawfully in any given situation. The ability to use force lawfully as a law enforcement officer is set forth in another statute, which we first looked at during my opening statements. This law requires that 4 requirements be met in order for law enforcement to employ physical force while in line of duty. Now I have to own up to something here. I know in the opening I told you 3 requirements, and now I'm changing it to 4. I swear I'm not adding to the law in real time. Our jury instructions have the requirements just split up into 4 sections. So for the sake of clarity and to make sure that I'm not confusing the issue at all, I have the same requirements split up the way your jury instructions have them. Our jury, the requirements are still the same, just divided up differently. So let's review them. First, the officer has to be making an arrest to use force. Second, the officer must reasonably believe that the force used is immediately necessary to make the arrest. They're immediately necessary. Think about that. You had to use that force to make an arrest in that situation. 3, the officer makes known the purpose of the arrest or the detention to the person of being arrested. You know, I've been trying to get to the heart of this issue throughout this trial, and we'll be returning to that. And 4th, a reasonable officer would believe the arrest to be lawful. Now again, you can see how the law is pulling out that as a separate issue than whether or not using force during the arrest is lawful. Law is saying there are 2 separate stages of lawfulness that have to happen. The arrest should, we would hope the officer believes it is lawful, but as we saw in self-defense, it doesn't matter whether it's lawful or not when it comes to whether the person using self-defense is allowed to employ that self-defense. But the officer does have to believe the arrest be lawful, and I think it is helpful here to illustrate that these are 2 separate things, which I think the state somewhat confused during their closing statements. The two statutes we've looked at here today are interlocking. If the four requirements for the use of force are not all met, all four have to be met, then someone cannot use physical force. A law enforcement officer cannot use physical force during an arrest. Again, unlike what the state just said, I'm not asking you to find whether the arrest was legal or illegal in terms of the facts that substantiated the ability to make an arrest that day, to ask someone to come into the station to be placed under arrest. What I'm saying is whether or not they could proceed to using force is the question here. And again, not what the state was just saying about excessive force. It is excessive force in a sense, but if, on a scale of 0 to 100 of force used by law enforcement, I'm saying it was excessive past 0. I'm saying they couldn't have gone past go. So I'm not saying one of the strikes used by the law enforcement officers was excessive. I'm not saying use of the taser was excessive. I'm saying anything, any force at all. Any force in this arrest was illegal because the requirements for force were not met. The state is actively trying to downplay the amount of force used here. You just heard them say it. The state also wants you to stick to your instructions, and I'd like that too. Luckily, you have instructions on physical force, and I'm going to read them to you. It's defined as force used upon or directed toward the body of another, including confinement. That is any amount of force, folks. We're not talking about an excessive amount of force. Again, I'm not asking you to find it somewhere on a scale of 0 to 100. I'm saying past 0, and we're already in the realm of illegal force. We heard officers have it within their discretion during testimony to just issue a citation and let someone appear for court later. Instead here, officers moved immediately to arrest Francis after he stopped answering questions, as was his right, as would be anyone's right. We heard Corporal Knight tell us that Mr. Keel was not advised of his charges prior to being taken under arrest. One of the 4 requirements that need to be met for an officer to use physical force against someone is that the officer, under 3 there, makes known the purpose of the arrest or detention, or believes that it is otherwise known or cannot reasonably be made known to the person to be arrested or detained. Again, these are in your jury instructions, so you'll be able to revisit all of this. We did not see anything to suggest that the officers could not have advised Mr. Keel while he was under arrest. He was not actively fleeing. He did not begin to step away from Officer Willis until Officer Willis stepped forward to arrest him before informing him of why he was under arrest. There was no reason that we have seen as to why officers could not have taken the time to meet the requirements under the law that they are all both instructed in the academies that they both said they attended, that they could not have met those requirements under law to proceed to using force during an arrest. Again, as I have covered, all 4 requirements have to be met. 3 out of 4 is not good enough. You have to get 100% on this test. The law says that all of the following must exist if physical force against another is used in making an arrest or a detention. We're missing that 3rd requirement. I asked point blank to the officers whether they told Francis what he was going to be arrested for. They told you no. I'm just asking you to believe what you heard. That brings us back to the statute that governs whether someone can use physical force in self-defense against unlawful physical force. Again, and actually, you might flip it back. Because the state highlighted it. I want to look at that last sentence and really actually kind of the last 2 we'd call it clauses. So whether the arrest is lawful or unlawful, and then unless the physical force used by the peace officer exceeds that allowed by law. I'm not asking, again, we talked about this, for you to get into whether this arrest was lawful or unlawful. That gets into probable cause and all these things that judges determine. I'm asking you to determine whether the force used by the peace officer exceeds that allowed by law. And again, I'm not asking you to find excessive force. I'm not asking you to place it on that scale, 1 to 100, find that as 100, find that as egregious. I'm just saying it passed 0, and that was enough. That was unlawful. We've been looking at the statute for what defines lawful physical force by a peace officer. It requires 4 things, 3 out of 4 were met. That's not good enough. It was unlawful. If law enforcement had met the requirements for using physical force, then we would not have an issue. I'd have no case to put on for you guys. But as we heard here in court from Corporal Knight himself, a corporal in the sheriff's department, they did not meet those requirements. Therefore, it was reasonable for Francis to use self-defense against what he correctly perceived to be unlawful physical force being used to effectuate an arrest against him. You heard Francis say that he did not hear anything from the officers about his charges before being arrested by force. Whether the force he used in self-defense is reasonable is for you to decide. But I will say generally, the courts have held that persons are allowed to use a similar level of force against your aggressor as is being used against you. In the first part of that melee, which we watched so many times, Francis and Officer Willis are shoulder to shoulder grappling, right? Francis only began using his fists after 7 strikes were delivered to his head, as Corporal Knight proudly told you. You heard that he did not.
Objection misstates the evidence. Clear approach.
You may. Go ahead.
Kevin Kent, there was no testimony from Officer Corporal Knight about how many strikes he delivered, and certainly not 7 strikes.
Your Honor, he actually multiple times said how he was proud about how many strikes he got onto his head. He said that.
I thought that he did.
Yeah, he definitely did. The state felt differently, but Corporal Knight corrected him and said, no, I delivered strikes to the head before he then came at me when he was trying to assist Officer Willis.
And what was your statement, Mr. Armstrong?
Yes, and my statement is that Corporal Knight testified that he delivered 7 strikes to the head of Francis as he was trying to assist Officer Willis, which is what Corporal Knight told us yesterday.
He said before
Yeah.
the defendant struck back.
Oh, no, I agree with that. I'm saying before the defendant used his fists, Corporal Knight said he punched him when he was grappling with Willis. That's what he said yesterday.
I don't recall that.
I know the state said something else, but Corporal Knight corrected the state. He said, yes, I was punching him before then in that sequence where he comes over to assist Officer Knight. He's punching at the client. He was proud of that fact. He said it twice yesterday in the stand.
You're talking about Corporal Willis or
Corporal Knight? Excuse me, Corporal Knight, sorry. Then both become a Corporal Sergeant. Corporal Knight, when he comes to help Willis, the state was saying, nothing, you're just coming with the ground stuff. He said, no, I punched him. He corrected the state on the stand.
I don't have a specific note on that exact sequence. I'm going to allow the argument to be made. I'm going to allow the state and the model to challenge and ask the jurors what they recall as to that specific statement from the officer. I'm not going to stop everything on that one point, which I don't think is a critical point in determination here, and have the clerk read back the record for us for that. So I'm going to overrule the objection at this time. The objection is overruled.
Okay, so as I was saying before, and let me clarify because it's really important to me that I don't distort the facts at all. So what I'm saying is that when it comes to whether the force used in your own self-defense is reasonable, generally the principle is it must be of a kind, right? Fist fights, use fists. Knife fights, you can use a knife. Guns, guns, right? It's a one-for-one kind of matching test, roughly. So what I'm saying here is that when the officers first moved to arrest Francis, we saw Officer Willis, who we saw having that initial interaction with Francis, shoulder to shoulder with Francis, right? And they're kind of grappling with each other. And then Corporal Knight, under direct examination from the state yesterday, said that when he first came over to assist Officer Willis, now Corporal Willis, that he delivered strikes to Francis. At this point, and then you saw him grappling with Francis. Francis turned his attention to Corporal Knight, who's now assaulting him. And then, yes, Francis did employ his fist. And you heard Francis had nothing to hide. He got up there and said, yep, that looks like my fist hitting Corporal Knight in the head, right? He said, no, actually, I don't think that fist is closed. Francis was being very open with you because he has nothing to hide. He was just employing reasonable physical force of a kind in his self-defense. You heard from Francis that he did not assault Howard and therefore was understandably confused about what this arrest was even for. You heard Francis was exactly where Howard left him after he left their argument over the lease. Law enforcement didn't need to look for Francis. That's because he wasn't hiding or fleeing. He wasn't hiding or fleeing because he had done nothing wrong. And he had no reason to think that law enforcement would be out looking for him or he had anything to be worried about. Again, I'm not asking you to disbelieve or to alter anything that you've heard or seen over the course of this trial. Howard's story, which has changed over the course of just his testimony yesterday, as exactly what transpired between him and Francis, should not be deemed credible. He wanted Francis off his property after he felt that Francis wasn't meeting the terms of their spoken, ambiguous agreement, the actual details of which are impossible to know definitively. He had every reason to make a report that would result in the eviction by arrest of his tenant, who he wanted gone. We saw no physical evidence of the assault on Howard. You heard Francis flatly deny that such an assault took place. Howard's story, as I got him to admit, has changed over time as to how he was hit or where he was hit. Yet Francis's story has always stayed the same. As we've already covered in detail, the officers did not advise Francis as to why he was arrested. This meant that the officers did not meet the second requirement, in this case, the third requirement that must be met in order for force to be used lawfully during an arrest. Therefore, Francis was justified in his use of force against the officers who were trying to use force unlawfully. Because Francis was justified in his use of force in self-defense, he is not guilty of assaulting the officers as he is charged. He did use physical force, but only in self-defense, which again is allowed if the force being used against you is unlawful to begin with, from the genesis of the use of that force. Now, you have to be very careful how you read the self-defense statute. It very clearly says that Francis is not allowed to resist arrest, even if the arrest itself is unlawful. We've talked about this a little bit, but I just want to revisit it. Be very careful with this part, because the state is asking you to interpret in a way that I believe is not the correct interpretation. Francis, this part of the self-defense statute is about, that middle clause, whether the arrest is lawful or unlawful, is about whether the arrest itself is supported by law, such as sufficient probable cause, like we talked about. And whether or not it is supported by sufficient law, this arrest, whether or not the arrest has enough underlying facts to support it, all of that, on those grounds, you cannot fight back against a law enforcement officer just because you disagree with why you're being arrested. But luckily, that is not what I'm asking you to find. I'm asking you to find that the use of the force during the arrest at all was unlawful due to this third requirement for force not being met by law enforcement that day. And this is what allowed Francis to use self-defense. If you find that Francis's use of force in this case was justified because the use of force by officers was not justified under their justification law, then you must find that Francis was justified in his use of force in self-defense and not guilty of assault. Remember, the state bears the burden of proving that such justification did not exist. Francis doesn't have to prove that. The state has to prove it did not exist. You did not hear the state make any effort to substantiate through their questions to the law enforcement witnesses whether the officers gave Francis reason for his arrest. They didn't ask either of them once about that. They apparently don't think that that legally mandated requirement is all that important. You've heard the state today ask you to gloss over some inconvenient details. But we know that it is a requirement. We know that it's the law. And we know that it wasn't met here. There it is, right there on your screen, written in law and in your instructions. As such, it was not permissible for law enforcement to employ force at all during this arrest. This unlawful force, in turn, justified Francis's use of force in self-defense. Follow what you saw and heard during this trial. The state did not prove beyond a reasonable doubt that Francis was not justified in his actions. Find that Francis was justified in his use of force in self-defense against the officers. Also find that there is not sufficient evidence beyond a reasonable doubt that Francis assaulted Howard. Find Francis not guilty on all counts. Thank you.
All right, thank you. Rebuttal from the state.
If you could just leave that slide up. Ladies and gentlemen, I think it would be helpful if you have your instructions out to turn to page 27. This is the paragraph that the court instructed you to add the or to before we started this morning. And the reason for that is important, as I'm going to explain in a second here. So looking at the defense's slide that's still up, 3, the officer makes known the purpose of the arrest. We're not disputing that. He said you're under arrest. It's in the video. I don't know if you caught this. You can hear it again. At that point, Howard, Francis, Mr. Mendoza-Keel says, no. What do you mean no? The fight starts. As the fight is starting, as they're grappling, Mr. Mendoza-Keel yells out, for what? For what? At that point, the officers, they're in a fight. We're not having a discussion anymore. We are detaining you and we're stopping this violence you're instigating against us. But you'll notice in this slide that the defense argued so vociferously, they left out the second and third clauses from paragraph 3. The clause 1 is there. Clause 2 and 3, the officer believed that the other person knew the purpose of the arrest. You didn't hear anything about that from the defense. It's not on their slide. Why? Why not? Well, you heard from Officer Willis that if they were in the yard talking, the defendant admitted, yeah, there was an altercation. Yeah, I smacked his glasses off. He didn't admit to smacking him in the face, having, dirt and rocks left on Mr. Leventhal's face, as you heard the testimony was. But he did admit to the officers, yeah, there was an altercation. I knocked his glasses off, right? I smacked his glasses, something to that effect. Well, when an officer hears, you're investigating an assault, you already heard the victim's point of view, and now the suspect is admitting to you, yeah, there was an altercation, and yeah, I got physical, I knocked his glasses off. Well, that's an admission by the defendant that he assaulted Mr. Leventhal. At that point, a reasonable officer would believe that the other person, in this case the defendant, at that point knew the purpose of the arrest. Hey, you just admitted to an assault? Well, guess what? You're under arrest. doesn't have to be verbalized. Or, and this is now in clause 3 of, I guess, numbered paragraph 3 on page 27, or the officer could not have reasonably made known to the person to be arrested or detained the purpose of the arrest. We have that here. They said, at this point, you're going to be placed under arrest. No. What do you mean, no? What if, the defendant had responded, okay, officer, for what? That would have been reasonable, and there's no indication that the officer at this point wouldn't have told him that. But we're in this situation where it couldn't have been reasonable. There was not this opportunity to reasonably make him known because he's already fighting at that point. The discussion is over. There is a fight going on. We're not having a academic conversation about charges while this fight is happening. So we agree. The purpose of the arrest was not verbalized by the officers, but it was reasonably known by the defendant, and the officer knew that. And the officer didn't have reasonable time because the defendant started fighting as soon as he was asking that. And just to back up, you're only thinking about this if you agree that there was excessive force by law enforcement officers. If you think there's no excessive force, you don't have to consider this because there's no physical force to be justified or justified against. There's no physical force by law enforcement officers. I'm gonna, one second. Can I have the slides back, please? Sure. So again, this is the instruction we're talking about, unless the physical force used by the peace officer exceeded that allowed by the law. That didn't happen here. There was no exceeded. What does exceeded mean? Excessive. Excessive force by the law enforcement officer. So you really don't need to even think about this issue of was the reason for the arrest announced. But back to what I said earlier, even if you believe up to that point, everything the defense said that this was excessive, there wasn't an announcement, it's not reasonable that he would have known why he was arrested. Even if you believe all that, you have to find that the defendant's force that he used was proportionable and reasonable to the force, if any, used against him. That's just not the case. There's apparently some dispute about Corporal Knight's testimony about how many strikes he had against the defendant and if any or all of those came before the defendant started striking back. You can use your recollection of the testimony, but the other thing you can do is watch the video and see if that's what happened, how many strikes you're seeing when this is going on. But that brings us back to the running, jumping, close-handed punch into Corporal Knight's head. Is that in any way proportional to anything up to this point that the officers had done? Placed him under arrest, grappled back with him, get put in a headlock, get punched themselves multiple times. The defendant, at this point, right before this running jumping punch happened, the defendant had just pushed Officer Willis off of himself. He was there. At that point, he could have backed away, said, all right, I'm at least sort of free. I can, at least try to calm this down. No, what did he do? He turns around, winds up, close-handed, swinging punch down into Corporal Knight's head. How is that proportional to anything the officers did in this entire sequence of events up to that point? It's not. And maybe I'm at risk of repeating myself, but on page 26 of your instructions, clause 4 there, I think that's also helpful to understand what's going on here. when making an arrest without a warrant, the officer was required to inform the defendant of the officer's authority and reason for the arrest unless, number 4, the defendant forcibly resisted before the officer had the opportunity to inform the defendant. That's exactly what happened here. Just briefly about this story by the defendant that there was no altercation, or sorry, I guess their position now is there was an altercation with Howard earlier in the day, but it wasn't physical. There's a lot of reasons why that's not credible, and it goes to everything the defendant said that's in dispute being not credible. So first, you heard a lot about the rent, and the defendant had quite a frankly confusing story about how Howard was somehow pulling strings with his boss to, I frankly don't understand it, but cut his hours, but at the same time increase his hours from 40 to 100 hours a week at a restaurant, I think it was, but also the defendant wouldn't be paid for these hours. It didn't make any sense. It just doesn't make any sense. I asked him about it, and it didn't make any sense when he explained it. But going back to motive, clearly the defendant thinks that Howard Leventhal is somehow pulling strings, messing with him, and that certainly gives the defendant motive to have hit Howard. Further, the defendant admitted he was in the yard or on the street working dirty work, working outside. Well, Howard testified that after he was hit, he noticed his face had dirt on it. How would that have gotten there other than from the defendant's hand that were, as he admitted, dirty from working outside at that point? So and you also heard from I believe Mr. Leventhal and the defendant that, the defendant was struggling to raise rent. So Mr. Leventhal lowered the rent. He still couldn't pay that. So he gave him this opportunity to work for him for rent. And clearly that didn't go well. But does that sound like the same person who's at the same time pulling strings with his boss to have the hours cut? Why, clearly Mr. Leventhal just wants to be paid the rent money he is owed. Why would it make any sense? It's just delusional to think that he's somehow whispering in the defendant's boss's ear saying, hey, cut this guy's hours. Actually, at the same time, raise his hours, but don't pay him. Because if he doesn't get paid or his hours are cut, well, then Mr. Leventhal is not going to get his rent money. It just doesn't make any sense. And again, another reason that his testimony, that you can consider his testimony completely incredible or uncredible, is his 3 prior felony convictions that he testified he has in the last 10 years. You can consider that in deciding whether his testimony is credible. So just to recap, the defense admits that, as far as the aggravated assault, everything happened. We're all in agreement about that. If there's not a self-defense justification argument that you find, we definitely have aggravated assault. They agree with that. So is there, again, back to this justification defense, does it exist here? I changed the slide. This is the most important part. A defendant is not justified in using physical force against another to resist an arrest that the defendant knew was being made by a peace officer. We definitely have that here. We're all in agreement. Whether the arrest is unlawful or lawful, we all agree on that. Well, I don't know if we agree if it's lawful or unlawful. We agree that that doesn't matter. unless the physical force used by the peace officer exceeds that allowed by law. It's just not the case. There is no excessive force. Even if you find excessive force, the force used by the defendant was in no way proportional or reasonable. For those reasons, he's guilty of aggravated assault. He's guilty of assault because he hit Howard Leventhal in the face, knocking his glasses off, leaving dirt on his face, and he disturbed his peace by shaking his car, yelling at him, being violent. Find the defendant guilty of all 4 charges. Thank you.
All right, thank you. At this time, ladies and gentlemen, when I read the final instructions, you probably noticed that I said all 8 of you must agree upon your verdict, and you also probably noticed that you're currently still numbered 9. In criminal cases such as this, the law requires a jury of 8 persons. We impanel alternates so that we'll have a sufficient number of jurors to decide a case in the event that things happen to people. People get, injuries or sicknesses or various things happen in their family. It actually happens with surprising frequency with our alternates. We don't ever obviously identify the alternate jurors because that person isn't selected until this moment in the trial. And that's for a really important reason. We select the alternate now because there's still a chance that the person that gets selected as the alternate could be called back to deliberate in the case if during the period where the deliberations are occurring between the 8 jurors that go back to deliberate, if something happens to one of those jurors, the alternate can be called back to be utilized as part of that as well. So we don't do this until right now. We're going to conduct a drawing randomly with the clerk calling out the name. All of your names are in a little bowl over here, and we're going to select the alternate juror by that drawing here in a moment. That person, however, is still going to be under the admonition to not talk about the case until they get word from the court that a verdict has been reached in the case. So at this time, I'm going to ask the clerk to draw that name.
The alternate will be Thomas Perkins.
All right, Mr. Perkins, juror number 4, you've been selected as the alternate. So as I already stated, you still remain under the admonition. So don't talk to anybody about the case until you hear from Ernie or someone else from the court to let you know that a verdict has been reached so that we can then release you from the admonition. There remains that small possibility that something could happen and we need to have you here to come back and deliberate. Ernie will retain your notes during the period while the other jurors are deliberating. But at this time, you're excused in that limited fashion. I probably won't get another chance to talk to you, so I want to just thank you for your participation in the trial and being willing to show up, do the Survey Monkey, and actually proceed through the whole trial up to this point. I know I've had other alternates express to me that it's a disappointing feeling and other people feel different ways. However you feel, I just want to make sure that you understand how much myself, the parties, and just the citizens of Coconino County appreciate your willingness to be here and participate in the trial. So thank you for all that. And at this time, you're excused on that limited basis, okay? Thank you. All right, at this time, the clerk will swear in the bailiff. If you'll come forward, Ernie.
You solemnly swear that you will take charge of the jury and attend to them during their deliberations, that while you are in charge, you will allow no one to communicate with them nor do yourself unless required in the legal discharge of your duties, and that you will return them to court when they have arrived at a verdict, so help you God?
All right, thank you. Ladies and gentlemen, at this time, you'll now go to the jury room to deliberate. Do take your notes and notebooks with you. The bailiff will bring you the admitted exhibits for your review just as soon as we have those ready for you. Sometimes jurors have questions during deliberations. If that is the case with you, do not hesitate to write down any questions that you have, if we can be of assistance. At this stage, all the questions that you have must be written on a form provided to you by the bailiff. Do not ask the bailiff any questions. He's not permitted to answer any questions for you. If you do have any written questions, they'll be brought to the court, and I'll discuss them with the attorney, and we'll do our best to answer them if we can. They must either be signed by yourself or the jury foreman that you'll select at the outset. So with that, we'll turn it over to you. All right, the jury has left the courtroom. I have the verdict forms, which I'll provide to the clerk. And if the attorneys will just make sure that we have good cell phones for you, and if the case agent, Corporal Willis, if you wanted to be called directly, otherwise if counsel just wants to call you, that's fine also. And then the jail, if we just have one of your phone numbers as well, just so we can let everybody know as efficiently as possible if we have any questions. The last few trials I've had, there have been a lot of questions from the jury while deliberating, so we'll see how this one goes. And was there anything that anybody needed to put on the record?
It's my understanding that the best practice is for the state to admit their closing slides only for appellate purposes. I'm happy to do that if there's no objection. I think we're on agreement that the only exhibits going back are exhibits 1 through 4, state's exhibits. So I just want to make sure we're on the same page on all that.
That's my understanding.
And we don't dispute that at all.
All right. And both slides, sets of slides from both attorneys, I assume you both want to submit those for appellate purposes only?
Yes, Your Honor.
Yes, Your Honor.
Both are admitted for that exclusive purpose, and those don't go back to the jury. All right, that'll be all.